Hi, my name is Eric Chen, and I'm a licensed attorney in Maryland and founder of Zen Legal Planning LLC. Let me begin by sharing a story about a father and a son. One day, a father suddenly suffers from stroke and became incapacitated. While the father became incapacitated, medical bills need to be paid and properties need to be managed. So the father wants the son to step in and make decisions on his behalf. However, no prior legal document was in place to authorize the son to manage the father's properties. Therefore, the son had to hire an attorney to petition the court for guardianship, which is costly and time consuming. To be appointed guardian to manage the father's assets, a bond needs to be posted to ensure the guardian doesn't abuse his power when managing assets of the incapacitated person. Unfortunately, the son could not qualify for bond due to poor credit, so the court appointed another person to be financial guardian of the father in order to manage the assets. The father's assets were quickly drained due to improper management of the assets and unnecessary court proceedings. And the father was forced to be moved from a well-equipped long-term care facility to a below-average care facility where the father doesn't have direct access to sunlight and there's no outdoor recreational space. Some of the problems could have been avoided with a valid power of attorney. You might wonder, what is the power of attorney? It's basically a written document that authorizes another person or agent. The person doesn't have to be an actual attorney to make financial or healthcare decisions on your behalf if you ever become incapacitated. A good example would be your spouse, your adult child, or brother or sisters. The power of attorney can be very broad in scope. We call it general power of attorney, or can be limited to specific acts. We call it limited power of attorney. The power of attorney can become effective immediately, or it can become effective when you become incapacitated. Legal term is called springing power of attorney, because it springs into action upon certain conditions. There are several advantages to power of attorney, including an inexpensive way to delegate power. It allows you to designate a trusted person to act on your behalf. It can be limited to a particular transaction, and you can avoid the need for guardianship proceeding, which is costly and time-consuming, as we talked about earlier. The disadvantages associated with power of attorney is that it could lead to abuse by agent if the person is not carefully selected. Also, different institutions may have different requirements for a valid power of attorney. Therefore, please be sure to check with each financial institution to ensure it complies with their requirements. You might wonder, gee, it's a lot of work to individually confirm whether power of attorney is acceptable by different institutions. True. That's also a reason why people choose to create revocable living trust by funding their assets into trust to be managed by trustees or successor trustees, since financial institutions are much more comfortable dealing with trustees than dealing with power of attorney. We'll talk more about trust later because I think it's the main and most important component of a complete estate plan. Thanks for watching this video, and feel free to ask any questions in the comment below.